Hello, everyone. Welcome to today's press call on the new rule on the public charge. I would like to turn it over to Diane Yentel, NLIC's President and CEO.
Thank you. Good afternoon. I'm Diane Yentel with the National Low Income Housing Coalition, and I'm joined on this call by colleagues from the National Housing Law Project, Housing California, Nonprofit Housing Association of Northern California, and the National Immigration Law Center to share together our strong opposition to the administration's latest attack on low-income immigrants. This week, the Trump administration published its final public charge rule, which is part of a sweeping and ongoing government-wide assault on immigrants. The administration designed this latest policy to do the greatest harm to low-income immigrants and immigrants of color by severely restricting their ability to access critical and life-saving benefits, including food, health, and housing assistance. With this rule, the Trump administration has dramatically expanded the definition of public charge to now include additional programs, including Section 8 housing choice vouchers, Section 8 project-based rental assistance, and public housing programs, as well as supplemental nutrition assistance programs, or SNAP, Medicaid, and parts of Medicare. So in other words, for the first time ever, an applicant for a visa or a green card would be denied if they need support for safe and affordable housing, food assistance, or health care. So this rule puts low-income immigrants in a cruel and impossible bind of having to choose between accessing the support they need to live safe and healthy lives or protecting their immigration status. Children, including U.S. citizen children, will be among those most harmed. As low-income immigrant families lose access to needed housing assistance, they will face increased risk of eviction and homelessness with tremendous personal and societal costs from the poorer health, lowered educational attainment, and lessened lifetime earnings that will result. By targeting immigrants of color, the Trump administration's new policy will widen racial disparities in housing stability. Immigrants already face significant barriers to securing affordable homes, from racism and discrimination to language or education barriers. And this public charge rule will exacerbate these challenges and put affordable homes further out of reach. So I'll turn now to Karlo Ng, who is the supervising attorney at the National Housing Law Project and an NLIC board member, to share more on the rule and its impacts. Karlo, I'll turn to you.
Thanks so much, Diane. So what I'll do in the next few minutes is provide a brief overview of the rule and also discuss its implications for immigrant families applying for and currently living in HUD-assisted housing. Overall, the public charge rule is designed to force low-income immigrants who are applying for admission or adjustment of status in the U.S., like applying for green cards, to choose between receiving critical public benefits and obtaining certain immigrant statuses. The rule, which goes into effect October 15th, is a drastic departure from federal immigration policies by making it easier for low-income immigrants to be deemed public charges for receiving certain benefits, including public housing, Section 8 housing choice vouchers, and Section 8 project-based housing assistance. Individuals who are determined to be public charges by the Department of Homeland Security are denied admission or reentry into the United States, or they are denied a green card. Historically, immigrants seeking admission or applying for green cards could not be considered public charges just for receiving these housing subsidies. But under this new rule, any immigrant who receives one or more covered public benefits could receive one or more of these benefits, including public housing and Section 8, for more than a total of 12 months within a 36-month period is considered a public charge. In situations where the immigrant is receiving two of the covered benefits for 1 month, so for example, if the immigrant is living in public housing and getting SNAP or food stamps, this counts as 2 months. Importantly, housing assistance an applicant receives before the effective date of October 15th does not count against an applicant, but in housing assistance received starting October 15th would be counted against the applicant. Other public benefits that count against the immigrant applicant include any kind of federal, state, local, or tribal cash assistance like Supplemental Security Income, SSI, and Temporary Assistance for Needy Families, TANF, Supplemental Nutrition Assistance Program, formerly called food stamps, and Medicaid with some important exceptions. Another part of the new public charge test is a prospective determination test, looking at whether the applicant is more likely than not at any time in the future to become a public charge based on the totality of the circumstances. To this end, DHS will weigh various factors to see if at any time in the future the applicant would receive one or more public benefits for more than 12 months within a 36-month period. These factors include the applicant's age, health, household size, assets, resources, financial status, and education and skills. Additionally, there are some heavily weighted factors that can help or hurt an applicant's public charge determination. For example, having a job where you earn at least 250% of the federal poverty guidelines annually for the household size would heavily weigh in favor that someone is not a public charge. Whereas if you're a student, you're authorized to work and you cannot show that you have a job now or you can get one in the future, that would heavily weigh against the applicant. Some immigrants who are eligible to receive this assistance and are already getting this assistance are not subject to the public charge rule. So there are certain exemptions that are written into the public charge rule. For example, certain survivors of violence, including VALA petitioners and certain trafficking survivors, are eligible for these housing programs and would not be subject to the rule. But there are also exceptions. For example, people coming to the U.S. as part of the Compact of Free Association, or COFA for short, folks from places like Micronesia, the Marshall Islands, and Palau are all eligible for public housing in Section 8. But they are not exempted from the public charge rule, which means that if they are receiving or they have received in the recent past or could receive any of these housing subsidies, it would count against them in a public charge determination. A really important point is that the rule does not count the housing benefits received by dependents of the applicant. So, for instance, the fact that an applicant parent has U.S. citizen children living in a unit subsidized by a Section 8 voucher, that should not count against the parent's application for a green card. But that does not mean that families as a whole won't be impacted by this rule. If a parent, for instance, from a COFA territory gives up their Section 8 subsidy because they're applying for a green card, that means that the family will be paying more out of pocket for housing and that housing will be less affordable for the entire family. So what is the impetus for this rule? Public housing in the Section 8 programs are already subject to very restrictive immigration status requirements under current federal law. Moreover, this final rule comes at the heels of the Department of Housing and Urban Development's proposed rule to get rid of mixed status immigrant families in HUD subsidized housing. It seems very clear that both the public charge and HUD rules are designed to scare low-income immigrant families into giving up vital public benefits that their families are eligible to receive. The rules force immigrant families to make impossible decisions about whether to keep a roof over their heads. The public charge rule will likely apply to some members of mixed status families currently living in HUD-assisted housing and who plan on applying for green cards through family-based petitions. Even if these members are not receiving any part of the housing assistance, the practical reality is that entire families will forgo housing assistance if they think that any family member receiving the assistance will jeopardize another family member's ability to get a green card, regardless of whether or not it actually does. We cannot underestimate the chilling effects of this rule as well. Regardless of whether the public charge rule applies to them, in the current climate, immigrant families will refrain from applying for housing assistance and tenants will give up their housing subsidies. Housing stability ensures that families can maintain jobs, access better educational opportunities, and have better health outcomes. The federal housing programs in particular serve as a lifeline for many immigrant families who are one step away from homelessness. It is absolutely unconscionable, given our country's current homelessness crisis, that the administration is effectively throwing families into the streets. Thank you.
Thank you, Karlo. I'm going to turn now to David Zisser, Associate Director of Housing California, to talk a little bit about the rule's impacts in the state of California. David?
Yeah, hi, thank you. Can you hear me?
Yes.
Great. Just a quick word about Housing California. Housing California is the voice in the state capitol for children, seniors, families, people experiencing homelessness, and everyone who needs a safe, stable, affordable place to call home. Our members include the most sophisticated nonprofit affordable housing development community in the nation, as well as local and regional organizations implementing cutting-edge approaches to ending homelessness, and residents of nonprofit-owned affordable communities. The public charge rule, in a nutshell, will force many immigrants to choose between an affordable place to live and the ability for themselves or their loved ones to become citizens or permanent residents. Many people think of immigrants as people here on a non-permanent basis, but I want to emphasize that that's not all we're talking about here. Not only will immigrants with temporary legal status be impacted, but even citizens would be fearful of the impacts on them and their families. Will they lose their home? Will their family members be unable to get a green card? I also want to address the myth that people, including immigrants who use public services, aren't, quote, standing on their own 2 feet, as Ken Cuccinelli suggested this week. For example, most people who use housing vouchers in California that can work, do work. 85% of voucher households that are not elderly or disabled include an adult who works or has worked recently or is likely subject to a work requirement through another program. They are standing on their own 2 feet while also getting some help from their government. Just a few numbers to illustrate the impact on California, which will be particularly impacted by this rule. California is home to about a quarter of the country's immigrants, around 11 million, including about 5 million non-citizens and 1.5 million undocumented immigrants. At least 1 in 6 children in California is a citizen with non-citizen parents. And of course, these children are at risk of falling into homelessness or living in overcrowded conditions or housing instability generally if their parents lose housing assistance or are too fearful to apply for it in the first place. California has significant numbers of families who benefit from federal housing assistance, which is a critical tool for addressing the housing crisis in the state. Through this rule, Trump and his administration are taking away this critical tool for ensuring housing stability. They are worsening the housing and homelessness crisis through this rule. For example, housing vouchers help around 300,000 low-income California families to afford the rent, more than all other state and federal rental assistance programs combined. Another 100,000 families benefit from project-based vouchers. The state's voucher holders reflect the diversity of California's low-income residents, and of course, this rule will primarily impact people of color, making this a racial justice issue. More than 1/4 of California's voucher holders are Latino, and 12% are Asian or Pacific Islander. Many of these families include immigrants, and many of them are mixed status, meaning they include some family members with legal status and some who are undocumented. We, as it's clear, vehemently oppose this rule. We will do what we can to make sure our members, including both affordable housing developers and residents and our many other partners, know what this rule does, who's impacted and who's not. Thank you.
Thank you, David. I'll turn now to Pedro Galvao, who is Senior Policy Manager at the Nonprofit Housing Association of Northern California. Pedro?
Great. Thank you so much, Diane. To tell everyone a little bit about who we are, the Nonprofit Housing Association Northern California is a long-standing affordable housing advocacy organization based in the San Francisco Bay Area, and we are celebrating our 40th anniversary this year. We represent those who build and preserve affordable housing in the San Francisco Bay Area, and our mission is to build a future where everyone in the Bay Area has an affordable and stable place to call home. And so when it comes to this rule, at a time when California is experiencing its worst housing crisis, this rule will force thousands more Californians onto the street, exacerbating our homelessness crisis and forcing many families to make the impossible choice of keeping a roof over their heads or their ability to stay in this country. It will exacerbate the poverty and suffering of our most vulnerable and break up our communities. We at MPH believe that every person deserves the decency and dignity of a home of their own, regardless of immigration status. We also want to emphasize that the affordable housing justice movement was built to serve the most vulnerable communities, and this rule will hurt all the communities we serve. Immigrants are making a tremendous contribution, especially to the economy of California, and it is a grave injustice that they should have to worry about keeping a roof over their head, or if they have the ability to stay in this country. For instance, according to the California Budget and Policy Center, immigrants represent 1 in 3 workers in California, and immigrant children make up, immigrants represent 1/3 of all workers in California, and immigrants are also driving much of the Bay Area's economic growth, where more than 40% of Silicon Valley high-tech startups from 2006 to 2012 have been founded by immigrants or children of immigrants. We urge Congress to oppose any proposals that target vulnerable communities, and we strongly oppose this rule and support the No Federal Funds for Public Charge Act, sponsored by one of our Congresspeople, Congresswoman Judy Chu. We will also be working with our members locally on how we can make sure people are not put in a situation where they have to make this impossible choice of putting a roof over their heads and their immigration status. And we'll be putting together an action plan to protect immigrants living in our communities. We will also continue to track the evolution of this rule and work towards ways to diminish its impact on all the people that we serve. Thank you so much for your time this morning.
Thank you, Pedro. And lastly, but not least, I'll turn to Jackie Vimo, who is the Economic Justice Policy Analyst for the National Immigration Law Center, to talk a little bit about next steps. Jackie?
Yeah, so I think that it's, again, important to mention that there is a 60-day waiting period until October 15th until these changes take effect. However, we anticipate that that deadline might actually be extended. The National Immigration Law Center, where I work, has announced that it is planning on suing. So, hopefully we'll be able to stop that. There have already been 2 jurisdictions in California that have filed suits yesterday to block the rule from going into effect. So I think that it's important to note that even though the clock just started ticking on the 60-day waiting period today, that there still may be some further delays. In addition, there have been actions taken by members of Congress, including the introduction of H.R. 3222, the No Federal Funds for Public Charge bill, which could potentially defund the public charge regulation. And there's lots of other possibilities as folks have been reaching out to express their dissatisfaction with the publication of this rule, given that when it was published and open to public comment, 266,000 people submitted public comments, and the vast majority of them were opposed to the rule by DHS's own admission. Also important to note that there's 2 other parallel changes happening. One to the Foreign Affairs Manual, which is how the changes happen from how public charge is applied when you're applying to enter the U.S. overseas at foreign consulates, and also the Department of Justice is also considering revising its rules for deportability and removal that would apply public charge to those rules. So those are also in play. So there's lots in play right now. I think that really what communities are focusing on right now is groups like the Protecting Immigrant Families campaign, which has been overseeing the response to the public charge proposal, is getting the word out to communities to ensure that they're well educated about this, because we've already seen a chilling effect over the last 2.5 years since versions of this were leaked, and we know that lots of people who are not technically impacted by this are confused by an 837-page regulation and have needlessly been disenrolling from benefits that make their families stronger. So yeah, that's the next steps. 60-day waiting period, and we will see what happens with litigation and potentially Hill action.
Thanks, Jackie. So it's clear from our speakers today that this change to decades of immigration policy is unconscionable, it's cruel, and it's unacceptable. And we'll continue working closely with partners from the immigration, health, food security, housing, and other fields, as well as with leaders in Congress, to stop this policy from being implemented before it can do the profound harm that it threatens to low-income immigrants and their communities. As you've heard, lawsuits have already been filed against this rule, and members of Congress are working through several avenues to prevent the administration from implementing it, including Representative Chu's legislation and language that is included in the House Appropriations Bill for PHUD. And we'll continue working to oppose all the administration's efforts to harm low-income immigrants of color and others. HUD recently proposed evicting over 100,000 people, including over 55,000 American children, through its proposed rule on mixed status immigrant families. Together with our partners, we generated over 30,000 comment letters, the vast majority of which were in opposition to the rule. But just like with the public charge rule, we expect the administration to still move forward in attempting to implement that change. So we'll build off our work through the Keep Families Together campaign to prevent HUD's continued effort to evict these mixed status immigrant families, and to oppose the forthcoming proposal from USDA to also evict mixed status immigrant families from its rental assistance programs. We're expecting that proposal to come out anytime in the next couple of weeks. And we'll keep working to oppose the administration's next radical public charge proposal, expected this fall, that could allow for low-income immigrants who have used certain housing and other benefits over the last 5 years to be deported. Another outrageous attempt to limit immigrants of color in America and to instill fear in the entire immigrant community. We will work to oppose all of these efforts. We won't stand for these radical changes to immigration policy. And now, Lisa, I'll turn it to you to field any questions that may come in for our speakers.
Thank you so much, Diane, Karlo, David, Pedro, and Jackie. I want to open the floor now for questions. Feel free to pose your questions either in the question chat box by typing it out, or by raising your hand, and I will unmute you. Okay. Seeing no questions and noting that it's approximately 12:26 p.m. Eastern Time, I'm going to move forward with closing the call. Thank you, everyone. Please feel free to reach out to me, Lisa Marlowe, at lmarlowe@nlihc.org with any questions. Thank you for your time. Take care.